Mediation is a form of alternative dispute resolution, ADR. ADR stands for that, not for alarming drop in revenue, which is what some cynical lawyers would say. And it's an alternative to going to court to settle legal disputes. There are various kinds of mediators. Family mediators deal with things like child access and that sort of thing. I don't do that sort of work. Community mediators deal with noisy neighbours, that sort of thing. I don't do that kind of work, although I have successfully mediated such matters as boundaries, rights of way, right to light, tree root damage and so on. Let's talk then about my kind of mediation, which is civil and commercial. It's a wonderfully satisfying way of resolving commercial and civil disputes, obviously. The reason it's so wonderful is that the parties are in charge throughout the process. The mediator is merely a catalyst to help them to reach their own solution to their own problems. And the outcome is simply a situation they both or all can live with. That's the point. What can they live with? There are no absolute winners and losers in mediation. It is a compromise, but not necessarily 50-50. It's just, I promise to do this, you promise to do that. Shake hands, sign the form, go home, it's done. On the day, everything is without prejudice. And what that means is that if concessions are made or matters are explained or whatever, and the mediation fails, none of those matters can be referred to later in the court proceedings. So people can make concessions and be open with one another, and that generally leads to a settlement. And it does normally lead to a settlement. My settlement rate after more than 100 mediations is 80%, and that's typical. But if matters don't result in a settlement, the parties still have their legal rights and can still go to court. Mediation's important, for one thing, because judges actively encourage it. They don't want to bother their pretty little heads with all the arguments. Let the people go away and have a chat, and hopefully the judge won't be needed. And under a case called Halsey, a Court of Appeal case, there's a checklist which says that if a mediation invitation is issued and refused, the refusing party has the onus of demonstrating that that refusal was reasonable. And that's quite a high test to pass. And if they fail, then there's a high probability that that party will have to pay both sides legal costs, whether or not they've ultimately won or lost the case. But never mind the downside, let's think positive. Mediation is a wonderful procedure whereby relationships so often are rebuilt. If parties go to trial, one side's going to win, the other side's going to lose. The judge can only award damages generally, and one side has to pay all the legal costs. There's blood on the carpet. The winner takes all, the loser loses everything. And that can be very, very serious. I've often started mediations where the legal costs to date are actually substantially higher than the figure the parties were first fighting over. And one of the techniques I use is this. Because generally about 30% of legal costs are taxed off or subject to detailed review by a costs judge, we can often work within that 30% by saying to the parties, look, you can concede quite a lot, and yet still with the 30% you will be financially better off, so can we possibly settle on that basis? But that's just one of the techniques the mediator used to try to convince the parties that it is far better to settle matters now and to get on with one's life. Lord Justice Ward, Sir Alan Ward, is a retired Court of Appeal judge. When he was on the bench, he was famous for making blistering criticisms of parties who'd refused to mediate. You've spent £100,000 on this case when it could have been settled with the help of a mediator in the early stages for £6,000. What are you doing here? And if you appeal against my judgment, how much more is it going to cost you? There's even a website, The Bon Mot of Sir Alan, which is really interesting. So when he retired, he felt honour bound to become a mediator himself. He's now a qualified mediator and is now the chairman of the Civil Mediation Council. There was a case of alleged negligence by a prominent businessman against a large firm of accountants over alleged tax negligence. It was felt it needed two mediators, an accountant and a lawyer. The lawyer the parties chose was Sir Alan. The accountant they chose, amazingly, was yours truly. And because I'd done about 100 mediations and Alan hadn't done one at all, I led him. How amazing is that? And he was wonderful. He was such a natural mediator. I was the hard cop, he was the soft cop. And the case settled. We've done one or two since together and we get on really well and we're good friends. That is how mediation can work very effectively. And by the way, the case did settle and saved about £500,000 in legal fees. As I say, with mediation, the parties are in charge. With litigation, the judge controls everything. And it's rather like dancing with a gorilla. You are in the grasp of the gorilla, and the dance stops only when the gorilla chooses to let go. With mediation, you are in charge, and you can stop the dance when you wish and on what terms you wish. So, don't allow the gorilla to grasp you if there is a chance, and there virtually always is, of the mediator being able to assist you. You can still have a trial if it doesn't work, but 80% do, and that's well worth trying. I could talk all day about mediation because all mediators have got lots of war stories they love to share. But I'd just like to close with one story which illustrates things quite effectively. This was a probate mediation between brother and sister who hated each other with a passion. Sister had left home at 16, got married, never came back again. Brother resented the fact that he was stuck looking after Mum in her last illness. Mum's last illness was very lengthy. Brother had to look after Mum, but when she died, he went off the rails, went off to Thailand, did the drugs, tattoos, underage sex. His sister just had no respect for him at all. And here they were arguing about Mum's estate. Sister had to clear out Mum's house and put all the furniture into storage. And one of the resentments she had was the cost of the storage. I asked the brother if there was some memento he would perhaps like to have of his mum. He said, yeah, sure. I want the family grandfather clock. I wound it every night after I made my mum's supper before I went to bed. So I went into the sister's room and said, this furniture storage obviously causing problems. I wonder if we can get the furniture out of storage. Is there something that you wouldn't mind your brother taking away? Clock, for instance? Yeah, she said, he can have that grandfather clock. That'll save a lot. So I went back to the brother and said, I think I've won you a grandfather clock. And after that, the rest of the dispute simply melted away. Why? Because we found the gold dust of something which one party desperately wanted, which it would cost nothing for the other party to give away. That was something they could live with. So in later mediations, quite often I've said to the parties, can we find a grandfather clock in this? They say, what do you mean? I tell them the story and we look for the gold dust. No cost, magic to the other party. And so often it leads to a settlement. That is why mediation is so fascinating.